Okay, I think almost all of you are back from the lunch break, so no one got lost in between. What I will talk about next is research ethics and legal compliance, which is maybe the most complex part of research data management. So in this regard, I'd like to focus on two topics. The first topic is informed consent. Why do we need informed consent? What does it mean to get informed consent? And the other aspect is data licensing, and in regard to data licensing, we first of all have to talk about intellectual property rights. So who has the copyright of a data set? Who can define conditions of reuse? What do we have to consider when we are reusing data from someone else, as well as how can we share data with others and enable others to reuse our data in a way we want the data to be reused. Okay, first topic is about informed consent, and according to the data lifecycle, informed consent is indeed a matter of the whole life cycle. So we need informed consent, which simply means we need agreement from our participants to participate in our study. And to do so, of course, we will get this consent in the data collection process, but it means that we have to think about how to get informed consent and what consent forms contain before, so it's a matter of the study planning. And informed consent is of special interest in regard to archiving, because consent forms can deny sharing data with others. So the idea to share data with others must be a part of the consent form. Okay, why do we need informed consent? Well, as I mentioned already, informed consent is nothing else than to get agreement from the participants to participate in the study. And there is a simple reason why we should get informed consent, and that is because if we do not get consent, it leads in general to poor data. What happens is that participants try to protect themselves if they don't know what happens with the information they give to us. So they will not answer on specific questions like income, sexual behavior, illegal behavior, or stuff like this, simply to protect themselves. Or they might even not be willing to respond to any of the questions. That means we have a complete unit dropout, and we might end up with a data set which is not representative for the underlying population we are interested in. Beside this ethical reason, there is quite a legal reason why we need to get informed consent, at least within the EU. And this once again refers back to the EU directive I was talking this morning already about. The Directive 1995/46, which will be replaced in the near future, hopefully. And according to this directive, we need informed consent. And indeed, we need informed consent in written form. There are some exceptions, especially for research, where informed consent can also be given verbally. However, we need to get informed consent. That's for sure, and that is defined in this EU directive. Moreover, this EU directive defines special conditions of informed consent, and it also defines rights of our participants. And these rights might be awful in regard to research, but these are the rights participants have. And the first right is they always have the right to withdraw from participation. They might have answered the whole questionnaire, and you might have dealt with their information already in your research project. But even in a year or in 5 years, they might be allowed to withdraw from participation, and that means you have to delete at least the personal information about them. Participants always have the right to access their data, to see what you have stored about them, and they have a right to get informed about how you're going to use this data within the research project as well as beyond the research project. And this refers to sharing the data with someone else. So if you plan to share your data with other researchers, you have to inform participants what it means to share data with other researchers, what it implies. And then, and this is what we have already, what we are talking about already this morning, personal data have to be stored within the EU about EU citizens. And this is what we will talk about in a few minutes, research data have to be anonymized. Both is a requirement of this EU directive. So what are the elements of an informed consent form? Well, to be informed, participants have to know certain things about the research project. First of all, they have to know about the aim of the project, and they have to know about who you are. And that means they have to know your contact information, which is especially tricky in research projects that only exist for a couple of years. So your research project runs out in 3 years, but participants have the allowance to get back to you in 10 years and ask what happens with their information. So contact information on the informed consent form is quite tricky, and you should think about a stable contact information there, which might be the secretary of your institute, but someone who knows how to get in contact with you again in a couple of years. You have to tell participants what participation in the study means. So you have to tell them we are going to interview you, ask you some question about your political behavior, about illegal behavior. We will ask you some questions about your person, so collecting socio-demographic information and all these stuff. You have to tell them how you will use the information for data analysis within the project. So what's the aim of the project once again, as well as beyond the project. You plan to share your data with others. You have to tell them how you're going to protect the identity of your participants by anonymization, by separating contact information and not handing over the contact information to anyone else, because this is not important for reusers. But you have at least to point out how you're going to anonymize the data. And last but not least, you really have to inform them about their right to withdraw from participation, as well as about the right to access their data and to get information about the use of their data also in the future. Once again, consent can or should be given in written form, and it should be given in advance to the interviewing. Sometimes this is not possible. So if you're going to observe the behavior of participants in a certain context, it doesn't make sense to get consent before doing the observation, because this will affect the behavior. That does not mean that you do not need informed consent anymore. You have to get the consent after the observation, which of course implies that you will lose a lot of observations because participants are not willing that their behavior or the behavior shown is used in your project. Well, that's bad luck. Moreover, in regard to research, we are allowed to get informed consent verbally. Also, as it is expressed by the directive, we should try to get it in written form. If you collect informed consent verbally, for example, because you're interviewing children which are not able to sign anything yet and to read through a consent form and understand it, you should at least try to record it, simply to ensure that you get informed consent, because at the end it's you that has to prove that you had informed consent. Okay, that's it indeed what I'd like to say in regard to informed consent. And after this session, or at the end of this session, we will once again focus on informed consent and what consent should contain. Are there any questions in this regard? If not, maybe the one important thing in regard to informed consent and data archiving is that archives in general just simply ask if you get informed consent. Maybe they would like to see the consent form once, but they do not take over all the consent forms of all your participants in general. Okay, because this contains personal information. There's the name of the participants on there, which means, yeah, these are highly sensitive information. If there are no questions in regard to informed consent, I'd like to make a short excursus on anonymization because, as shown before, anonymization is required by the EU directive as well as, or consequently, of the national data protection laws in the EU. So, why do we have to care about anonymization? Well, first of all, because there is a legal requirement, but there's also an ethical reason, because we simply have to protect our participants from harm. If the information we collect about them is used against the participants, we won't find people willing to participate in our studies tomorrow, and that would mean the end of social science and life science research. So we really have to care about the people or the participants in our studies, and we really have to protect them from harm. To identify observations or participants in a study, you can in general distinguish between two types of identifiers. The first type are so-called direct identifiers. These are simply the name of the participants, contact information, pictures, maybe the voice if it's a pregnant voice, and all these things that directly lead to a person. Direct identifiers are not that problem, as you will see in a moment, at least not in quantitative analysis. In qualitative analysis, it's a bit more tricky. Indirect identifiers are the combination of certain information collected about an observation. And this is really tricky, because it means that you simply add up additional information in the data set and you end up re-identifying a person. As a simple idea, you might think about, you run surveys at universities in Europe. And you know the university, TATU. You know the Institute for Sociology, for example. And you know the position of the person, the leader. And if you now tap in your computer, leader for social sciences or for sociology in TATU, you will directly find out who it is. And this is what happens in quantitative data sets quite often, that the combination of certain information directly leads to re-identifying a person. And this is what we have to care about when we anonymize our data. Due to the fact that we might have or we might run into trouble with re-identification, anonymization, we should think about anonymization before in the step of study planning. Once again, you have to describe how you're going to protect your participants in the informed consent form. And that means you need an idea how you will do this. And this is also of importance according, first of all, to the type of data you're going to collect. Qualitative data, doing interviews with only a handful of persons, are much harder to anonymize than quantitative data. And, now I forget my second point I'd like to make. Sometimes you should really carefully think about the information you're going to collect in the interviews, no matter if it's qualitative or quantitative. Sometimes researchers tend to collect all the information they might grab, but they do not need this information anyway. So you're interested in behavior at work, and you have questions in there about illegal behavior on the street. That's not necessary, and you can protect participants from harm not asking questions you do not really need, especially when they refer to behavior which is critical. So carefully think about what data you're going to collect. Do you need this information? And then think about how you have to manipulate your data to ensure that they are anonymized. Okay, how can we anonymize data sets? Well, in regard to direct identifiers, the thing we have to do according to the EU directive is we have to separate contact information from the research data. I think this is not a big problem, and for quantitative data sets, this is normally done by a unique identifier, a numerical identifier, that leads back to the contact information if it is needed. But you should put this contact information in a separate file, encrypt the file, protect it by a strong password, and store it within the EU. For qualitative data, what you should do is you should use meaningful pseudonyms. So not use the real name of the persons being interviewed or of persons related to the one who is interviewed, but use pseudonyms. And if you use pseudonyms, you have to use these pseudonyms consistently throughout the whole transcript of the interview. What you can also do is you can remove sensitive information or sensitive variables, at least if you do not need them. So you asked about illegal behavior because you thought you would need it, and then afterwards you recognize I don't need it anyway. So you might separate it from your research data set. Once again, encrypt it, protect it by a strong password, and store it separately within the EU. In regards to qualitative interviews, especially if they are recorded by webcam or visually or audially, anonymization is quite hard. So what you can do, of course, you can do voice alliteration or image blurring, but that costs a lot of time and effort. In general, you need special software to do so. And yeah, sometimes you cannot do it at all, because if you would like to observe the behavior of people while they are interviewed, their mimic, you cannot simply do image blurring. That would mean that you cannot use your data anymore. In regard to indirect identifiers, it's quite hard to think about anonymization, because you have to figure out on your own which combination of information might allow others to re-identify an observation. If you've figured out which type of information this is, what you can do is you can restrict the ranges of variables. So we are not talking about the leader of a political institute, but simply of a research institute, but simply about a member of a research institute, which at least makes the group of potential participants a big huger. And what you also can do is you can do low-level aggregation, which simply means we do not keep the information as detailed as it is, but aggregate it to a higher level. So it's not the University of TATU anymore, but it's a university in Estonia. So maybe this helps already to anonymize your data so that the marginal distribution of your variables become bigger, the group of people being in each of the category becomes bigger. Any questions in this regard?
I'm not very aware of this EU
directive, yeah.
But do we always have to anonymize? If the interviewed people agree that yes, we can.
It would be on my next slide.
Sorry?
It would be on my next slide. Of course, what you always can do is you can ask for consent on not anonymizing the data, which is special of interest if you're going to analyze the mimic of persons, and through, that's why you record the interviews visually. It doesn't make sense to make image blurring then. But you can get informed consent to use the data anonymized and to share the data anonymized. And there are special institutes for sharing non-anonymized data. These are so-called CQ Data Center. Astrid, will you talk about CQ Data Center later on? No? No, okay. Then I will do so. CQ Data Center are parts of data archives, and what they do is they really provide unanonymized or weakly anonymized data. Researchers can go there, can do their analysis, and before they see the output of the analysis is checked by a member of the archive, and the member of the archive decides if the output could be used to re-identify an observation. If that's true, the researcher never sees the output, but is asked to change the analysis. So this is a way to use data in an anonymized way, also for the analysis, and to ensure the protection of your participants. But sometimes, especially in regard to qualitative interviews, of course, when you interview experts like politicians, they are willing to be cited under their real name. So it's no problem at all to get consent from them. Anything else? Otherwise, I have one additional slide in regard to anonymization. The first thing what you should keep in mind is when you do your anonymization, document what you have done. Document the changes you have undertaken. This is of special importance in regard to qualitative data, simply to show reusers where you have replaced the names, used pseudonyms and stuff like this, where you have deleted information due to being too risky in terms of re-identification and all this stuff. So document it. What you should avoid is, first of all, inconsistency. So think about how to anonymize your data first, and then develop a strategy and then use this strategy consistently. So if you have the transcript of a qualitative interview and you start up at the first moment when the respondent mentions her or his name and say that this is respondent 1, and later on you just simply use a different name for the same respondent but not respondent 1, this is an inconsistency which makes it hard to understand who the respondent was, if he or she was talking about her or himself, or of talking about someone else. So think about how to anonymize and then use it consistently throughout the project. The most tricky thing about anonymization is the problem of over-anonymization, and this is what you also definitely have to avoid. And at that moment, we would need a lawyer, because the EU directive, as well as data protection laws, national data protection laws, are quite tricky in regard to anonymization. The requirement is that it should not be possible to re-identify a person in a simple way. Whatever this means, I have no idea. For your own research data, you have to find a balance between anonymizing, so protecting your participants, and keeping as much information in your data set as possible. Because it doesn't make sense to restrict a variable to one category only. This is no variable, it's a constant, it's not usable anymore. Okay, and the more you anonymize, the more information you lose, and the more restricted you are in your data analysis. And that's why you really have to think about, or really have to find a balance between anonymization and usability of your data. And then last but not least, if anonymization is impossible, this is what I mainly talked about. You might try to obtain informed consent using the data non-anonymized. You might control the access and the regulation of reuse, maybe due to or via a secure data center. And of course, you might put an embargo on your data if this embargo helps already to solve a problem. So if you observe illegal behavior, which could only be brought to the judge for the next year, and the embargo is longer than a year, you protected your participants already because they cannot be judged afterwards. Anything else in this regard, or any questions in this regard? Once again, I think informed consent and anonymization are one of the really heavy topics of data management. And in general, the problems arise once you really have to do this. So it is, at the moment, it's all clear, it's all fine, it's all perfect, but once you sit down and have to write down the consent form, it really becomes hard how to describe the anonymization strategy, how to explain children what you're going to do if you want to interview children, and all these things. There are a lot of good books and papers out there explaining how to anonymize data. There are a lot of good books out there giving advice on how to write consent forms. And what you can always do is you can get in contact with data archives, and they might help you how consent forms should look like and how you can anonymize data. Otherwise, I'd like to go ahead and talk about data licensing and data ownership. Once again, this topic is a matter of the whole research data lifecycle, because licensing is something you have to take into account already in the study planning. This is of special importance when you plan to archive your data, because archiving at a repository or a data archive in general implies that your data will be licensed. And as I will tell you later on, data can be licensed many times, but that is problematic for the data owner or for the data archive. And of course, you should also think about licensing your data in regards to data collection, and maybe tell participants how you're going to protect their identity by simply restricting the access to your data, which might be a part of licensing already. Okay, talking about data licensing means first of all talking about intellectual property rights, because this is where we can define the ownership of a data set. Intellectual property rights cover scientific work. So when you write a paper, this paper is protected by intellectual property rights, and we all know this because when we use this paper in our own research, we have to citate it in an appropriate manner. The tricky thing about intellectual property rights, first of all, is that it does neither extend to an idea nor to a single fact. So these two things are quite tricky. The idea, well, let's take the example of Albert Einstein and the idea of relativism. This idea itself is not protected by intellectual property rights. Whatever Einstein wrote down about the idea is protected by intellectual property rights. So it must be written down somehow that your idea becomes protected. Likewise, and especially in regard to social sciences and life sciences, the fact that single facts are not protected by intellectual property rights are always a bit tricky, because it means that a single piece of information you collected is never protected by intellectual property rights. Personal information, at least within the EU, remain the ownership of the person the information is about. But when you collect informations like the result of a football match, this result is not protected by intellectual property rights. What happens is that when you set up a data set, this data set is protected by intellectual property rights, because a data set is nothing else than the organized collection of single informations. So a single piece of information within the data set is not protected by intellectual property rights, but the overall structure of the data set is protected. Is this clear? Okay, so we can go ahead and say that yes, data sets are protected by intellectual property rights. The second tricky thing about intellectual property rights is that they are not universal. They vary from country to country, and I will show you in one of the next slides that there is an EU directive according to intellectual property rights on data sets as well. But beyond this EU directive, intellectual property rights vary also within the EU. The UK, for example, has a quite strong intellectual property right in comparison to Germany, Denmark, or the Netherlands. The second thing in regard to being not universal is that intellectual property rights are territorial rights. And that means it matters where the work of someone else is reused and not where the work of origin was created. So if you set up a data set in Estonia and I reuse it in Germany, I am bound to the intellectual property rights of Germany, but not of Estonia. And that makes the world of intellectual property rights quite complex and quite confusing. Any questions in this regard? Yep.
Do you have to declare sort of a copyright of my data set, or is it something that's already granted?
That's why we will put a license on it in 2 slides.
If I don't put any license on it, what happens?
Then it indeed depends on the national law where the work is reused. I can tell you that in Germany it's quite easy because the default position, as long as there is no license on it, is simply I'm not allowed to reuse your work. I'm allowed to read your paper, I'm allowed to citate your paper, but I'm not allowed to do anything with it. I'm allowed to have a look at your data set, but I'm not allowed to use it for my analysis. That's the default position. It might not be the case for someone in India, China, or whatever, where the intellectual property right simply says that as long as there's no license on it, do whatever you'd like to do.
So I should put a VPN to China.
Okay, anything else? Okay, when we reuse the work of others, so I think there is no need to talk about that we have to citate it, that we have to pay credit to the data creator of origin. What we have to distinguish in terms of reusing data or enabling others to reuse data is the copyright and the right of usage. The copyright simply assigns the ownership of a scientific work, so of a data set. And it protects against unauthorized copies or derivatives of the work. But it does not define any conditions of reuse. This is done by the right of usage, which simply says that you're allowed to reuse this work under this and that conditions. And this is what is defined in general in a license. So once again, the default position normally is that as long as there is no license on it, you're not allowed to use it. At least within the EU, but what happens outside the EU, well, it simply depends on the specific country. So when we produce a data set and we want to ensure that others cannot do with this data set whatever they would like to do, what we should do is we should put a license on it. Indeed, a license means the opposite, because a license means to give permission to someone to do something. But of course, this could also imply that the license simply says that my data set cannot be used by someone else. And hopefully this is not the case how you will license your data, because we all want to have open data and open science. To put a license on your data set, what you first of all have to do is you have to clarify who is the owner of your data set, because only the owner of the data set is allowed to put a license on the data set or give you the allowance to put a license on the data set. This might be tricky because it's not necessarily you who is the owner of the data set, also you have created the data set. If you did so in the context of your working contract, the data set in general belongs to your employer. Same might be true in regard to funders, whereas most of the funders do not demand ownership of the data sets collected. What some funders do is they demand for sharing the data with others. So what you should first of all do is check who is the owner of your data set, and then check if your institute or your funder has license templates, which is quite normal in the meanwhile. And if that's the case, you should simply fall back on these licenses and use it for your own data set or your own scientific work. What you should keep in mind in regard to licenses is that they can be irrevocable. That means once there is a license on a data set, the license exists. And you as the owner are allowed to put a second and a third and a fourth license on your data set. That's not a problem. But for me as a reuser, I don't have to care about all these licenses. I can simply choose the less restricted license and reuse the data in regard to this less restricted license because I have never seen the other licenses. So if you put something in the open domain, so everyone is allowed to do everything with it, and 2 weeks later you recognize that your data are highly sensitive and weakly anonymized, and that you heavily have to protect them, it's already too late. So think about what type of license you need before you simply put a license on it. So that's why licenses might not be suitable for third-party licensing. When you put your data to a repository or to an archive, it is licensed in the process of archiving. That means the conditions of reuse are defined by the repository or by the archive. And if there is a license on it already, it means that the archive itself cannot control the reuse of the data. And of course, some licenses are not suitable for confidential or sensitive objects. So if your data are weakly anonymized, they are definitely not for the public domain or for a CC BY license, which allows everyone to reuse the data however they'd like to do so. What I'd finally like to show you is simply how licenses of data archives look like. So this is just an extraction of the UK Data Archive end user license. So what end users have to care about when they use the data archived by the UK DA. And it's only an extraction, so it doesn't show everything. The first thing, and this is quite normal for research archives, is that the data they provide are not for commercial purposes. So in general, we only provide data for academic research or academic-related research. Downloading the data from an archive does not imply any transfer of intellectual property rights. For most of the data sets in data archives, the archives itself are not their intellectual property right holders. They simply have the right to share the data with others, but the intellectual property in general remains with the data creator of origin. What is also quite common for data archives is that they share the data, but they do not guarantee for the quality of the data. This is up to the data creator of origin, or is the risk of the person who reuses the data. Of course, we check for the quality of data, but we can never ensure that the data are not faked. Then there might be additional conditions that you have to respect, like specific access categories. You're only allowed to use the data in-house, in the archive, in a secure data center, and the output is controlled before you can see the output. This might be a special condition. You, of course, have to ensure the access to the archive you have. So you register there with your name, you get a password, and you have to protect the password so that others cannot simply use your account to access and download data. And, of course, you have to pay credit to the data creator of origin, as well as, in general, to the archive where the data are stored. But once again, this is only an extraction. The whole conditions of reuse or license for reusers is much longer in the UK DA. Any questions in regard to licensing? If not, I have this slide with further readings according to licenses, intellectual property rights, and informed consent. And what I'd like to do now, of course, once again, is do a small exercise. Once again, focusing on the data management plan template on section number 4. And according to the fact that we are quite a huge group, I'd like you to split up into 4 groups, whereas 2 groups will focus on the same topics. So what I'd like you to think about, first of all, is informed consent. 2 groups to think about informed consent and outline the process how you're going to obtain informed consent. That means what information has to be included in the informed consent. What do you have to care about setting up your consent form, for example, in terms of language you use? For academic researchers, you might use another language than for children or stuff like this. So think about how to provide the information people would need to really sign an informed consent form, and that you can really be sure that participants understood what they are going to sign. And the second group should focus a bit on intellectual property rights. On the one hand, what you have to take care about when you're going to reuse data from someone else. So what can conditions of free use mean? What can they imply? And on the other hand, how would you license your data if you'd like to share them with someone else? What conditions of free use would you put on your data? Maybe we could do it the same way as before. Could you just simply raise your hands who's interested in part A? And in part B? Okay, so maybe you can just check if you would like to split up in 2 groups or in 4 groups or in 3 groups. So I'm not quite sure how big the groups will be. For the librarians who had a discussion with Astrid before, if you would like to continue this discussion, you're welcome to do so.
But you're also welcome to join
Yeah.
groups, of course, because that might also be interesting.
And of course, at the end, I'd like to ask each of the groups to briefly present the results of the discussion. So we will start off with your group. You was informed consent.
Yes, we were informed consent. I hate talking to the microphone. So we have had a very interesting discussion, and the first point that we touched upon was we all know that when we are asking for the informed consent, then we have to explain the aim of the research, what the research is about, what I'm doing, and what I'm going to do with the data. But it turned out that very often when we explain the aim of the research, that information somehow may influence the results, the outcome of the research. And it's very difficult to find this to set boundaries to which point I specify and what parts of my aim and of the essence of the research I leave untold, so to say. And yeah, this is a tricky point. The next point that we discussed was related to the property of the participant, because one of the members of our group studied the property of the cows, the cattle, and she identified them by their numbers. Every cow in Estonia is somehow identified and has its own number, it's registered. And she only used these numbers in her data, but she didn't publish and didn't make it public in the analysis. There she remained quite vague. But actually, if this data has to be reused somehow in the future and made public to a certain extent, then theoretically it is possible to track the owner by this registration number of the cow. And it may cause, as far as it was related to some kind of disease, then it may cause some financial, economical damage to the owner, this information. And what we were thinking about is maybe the solution would be to put some kind of time limit for into the license, for example. If we decide to reuse this data, then we give the permission to reuse this data, but only after 5 years or 10 years of time. So then when this information that there was an instance of a certain disease in the herd of a certain owner is no longer important.
But you can also anonymize more.
Yeah, we also were thinking of, for example, when we deal with people, then we change names people's names to numbers, But with cows, it is possible to do the other way around. So we change the registrator numbers into names of cows. So that is another solution. Yeah, we anonymize the cows. But again, I think the size of the database is quite huge. So maybe quite complicated to anonymize that. Have I left anything unmentioned? Yeah, that's right. With my data, some of my participants, I conducted video interviews, and one experiment took place in Russian Federation, and the other took place in Estonia. So technically, if I am to somehow make my data public, then I have to deal with this data protection rights and laws, not only EU data protection rights, but also Russian data protection rights, because these participants, they are the citizens of another country. So but again, if my research takes place in the EU, so do I have to still follow the data protection law that is adopted in Russia, or it's as far as it is published in the EU and I do my research, my analysis on the research at the University of Tartu. So does Russian Federation law of personal information protection apply to my data?
This is a really tricky question. I'd say that you might simply fall back on the data protection law of Estonia, but the question is what happens when you enter Russia the next time?
I have to go there quite regularly.
But do you actually collect the data in Russia, or?
Yeah, my sample, this is a more theoretical question, because I have known, as far as this, my sample contains a lot of sensitive information. I can't imagine, these are video interviews where power relations are studied. So I don't think I will ever be able to make it public, because it's impossible to make it anonymous. But theoretically, as far as I'm interested in intercultural communication, and I can imagine the situation that I'm going to collect certain data both in Russia and in Estonia in order to compare them. Then,
I have two comments on it. The first comment is that you should always respect the data protection laws of the countries where you have collected data.
mm-hmm.
So that means in your case, respect the data protection of Estonia as well as of Russia. And at least for the EU data protection laws, the national protection laws within the EU, I know they do not differ so much.
Mm-hmm.
The second comment is that the EU directive I was talking about only defines minimal criteria which have to be respected by all of the national data protection laws within the EU, but that does not mean that data protection laws within the EU are identical. So they differ from country to country.
Okay.
And this is also something you have to keep in mind.
Okay.
And in regard to the question to share your data, well, I think there are these two options. The first option is you have these secure data centers where you can share data that are weakly anonymized or non-anonymized. But sometimes, well, it's simply to say that my data cannot be shared, and that's the fact.
Yeah.
This happens, and that's okay. But I mean, as long as you know why and as long as you thought about sharing, it at least shows that you care about the open access idea.
Yeah.
Because as soon as you put participants at risk,
Yeah.
sharing is just
It's
a
impossible.
no-go.
Yeah.
Because to protect the participants is the most important thing, and sharing your data is then simply not possible, and that's okay, as Sebastian said.
Have I mentioned everything that we have been talking about? Good. That's interesting. Oh yeah.
Thanks. Maybe in regard to your first two points of discussions. According to the embargo, you might of course say that my data will be public in 5 or 10 years, but what you should think about is that data in life science and social science highly depend on time. So in 10 years, no one will use your data set anymore. And this is something you should take into account when you put an embargo on your data. So in general, archives accept embargoes up to 1 year. Of course, it also depends on when you're going to archive your data. But after 5 or 10 years, no one will be interested in your data anymore. There will be newer data available already in the meanwhile. So this is something you have to take into account when you think about an embargo. In regard to this information, what information do you hand over to your participants before the interviewing? That's always a tricky question, because it's always the fact that it might affect the behavior or the answers you will get. As I told you in the introduction round, I worked for an electoral study before, or a comparative electoral study before, and what we in general expected to be in the informed consent is simply to tell people that this is a study about electoral behavior in the last national election. And not much more. It can be quite short, people know what it is about. And for the informed consent, what you should think about, what is always a really good information, is the name of your institute. Your institute is known in Estonia, and it creates some kind of trust. And if people know where you're from, they're more willing to participate. At least I hope it is the case in Estonia.
Because the name of the institution already gives away too much information.
I have I'm going to do a study about sporiosis in Estonia. It's a parasite causing diarrhea in humans as well as cows and other species. So if I tell them that I'm going to ask you about crypto, then they will be, okay, this is a leading thing. If they ask if I ever had diarrhea, then I say no, because I never had crypto. But if I don't ask them straight off that I'm going to ask you about crypto, but something about other parasites, or maybe even that is quite leading, and people, if I ask that from our students, who all know who I am, which department I work, and what my PhD is going to be about, then it's kind of, yeah, it's a tricky thing.
It is. What you can do, of course, is you can try to get informed consent after the interviewing. So ask participants if they're willing to give you, to provide you a few answers, and then afterwards tell them what it's all about, and get informed consent that you are allowed to use the information you have collected. Of course, this is a high risk that you do a lot of interviews where people say afterwards, no, we won't allow you to use the information. But this is, let's say, at least the exception, which is defined in the data protection laws according to research. So this is the backdoor which is still open to enable researchers to collect data where the information cannot be provided in advance.
You could mask it into a bigger survey of health, and maybe ask the university to spread that. If you do a health survey, this is a health survey, and you ask them other questions, and you put your own specific questions in there as well. And later you can say that we studied those diseases, but it's like a consent to a health survey would be very reasonable. You're not lying there. And later you can explain further if you want to after they completed.
Then my question is, should I mention my name in the beginning of the survey? Because as I said, the people that are going to fill the survey, they all know who I am and what I study. It's really so.
You have to. You mention the department and have someone from the university to spread questionnaire.
It's in the student.
Yes, always in the student.
Participants will ask who sent them. No, I mean it's a tricky thing, and this is what makes research data management indeed so interesting. That every study is different, and every survey is different, and all the problems. It's always something new, something different, and in most cases there is no single best answer, unfortunately. I think you mentioned, or we discussed most of these things on this slide already, which is giving a short wrap up on how or the information that should be included in the consent form. There is one thing I'd really like to stress out, and this is once again to think about what you will do with the data beyond the research project. Because what we can find in informed consent forms quite often is a formulation like the data will only be used within the research team. And this clearly forbids archiving, because the participants signed for the use of data within the research project and that the data will only be used by the research team. That means the team is not allowed to hand over the data to someone else and to share them with someone else. And this is something you should really keep in mind when you set up your consent form. Think about not to include formulations like this. And really tell participants that you are going to share the anonymized data and that other researchers are allowed to access this data and to reuse this data. And if you explain what anonymization means and that they cannot be re-identified in the data set, participants in general are quite willing to sign a consent form where sharing is included. Any other question in regard to the consent form? Otherwise, we have the group with the intellectual property rights.
Well, we had a very varying discussion. Gosh. And I guess the takeaway was that you have to really, the best practice is to figure out what you allow your data to be, what you allow your others, how do you allow others to handle your data, and set up a repository, and then everyone can either take your data from there and they know and they can cite it and whatever. And this eliminates a lot of problems that can arise. I hardly made any notes.
We discussed about the entrepreneurial partners.
Right.
In the beginning we discussed it's easy in public university what uses only public money. So they are mostly regulated, some regulations by finances, some regulations by university, and if there is only one source of money and one type of research, so it's easy with intellectual property rights.
Yeah.
Generally.
Yeah. Whereas for the PhD students it might differ a bit, because for them it's sometimes not clear who is the owner of the data. Is it the university they are studying, or is it the PhD student itself? This heavily depends on the contract they have with the university. Because at least in Germany, normally when they just only study there, the data they collect belong to them. Because once they are employed there and collect this data within a project, the data belong to the project and used to the university, of course.
We have the same.
So sometimes it's tricky. It's the same as funders, because our biggest German funding agency, they do not fund a single project at the university, also they do so by contract, but they send the money to the university, which means any intellectual property rights that arise from the funding grant refers to the university and not to the institute or the project rights. So sometimes it becomes really tricky and really hard to understand where the ownership is.
And on the other hand, yes, we also discussed what actually means, what can others actually do with the data. And it really depends on the field. If I have some questionnaires, and I think there's a few other people who are interested in psychometric analysis, but probably no one will find any other application to that data. But if the data is then possibly part of developing some device, then this data becomes much more valuable and becomes much more important to set the rules up front. And I guess again, as a student, you can't really predict all the possible outcomes, because you don't, and often people learn by experience. And that's why I guess courses like this are necessary so people could actually have an idea that what could happen with the data and what they should prepare themselves for.
Yeah, we discussed several cases, and in very various cases, like between student and supervisor. What if student arranges project by himself, for example, and it was interesting, but in every case we found that the solution might be and probably will be different. So, and not talking about if there will be a third party from private sector, for example. So it will be different every time, probably we concrete output.
But let's say in regard to reuse and anonymization, creating scenarios how the data might be reused and how someone might try to re-identify observations is always a good idea to deal with your own data. So indeed, what do you exactly have to do always depends on the data and the type of data you collect and the information that is included in the data set. But to create such scenarios always helps to understand what can be done with the data set and what you have to care about in terms of anonymization or in terms of restricting the access for reusers.
Yeah, from point of view of a public financer, it was very easy. We have, let's say, we reuse of the data, so we would like to see that the data will be reusable after the research. But there are several buts, and these buts has to be followed, and if all those are eliminated, so all which left, it should be freely reusable.
Mm-hmm. Okay.
Maybe just to stress that again, because you mentioned that you discussed several situations where, for example, students and the supervisor are working on a project, and I mean that's a situation where you have a collaborative project possibly, and for collaborative projects it's really important beforehand to clarify what the ownership of the data is going to be, so that you don't have a situation where one person leaves the project team and suddenly claims, yeah, but this is my data and I'm going to take it out of the project. So this is something that is really important to discuss when the project starts, to prevent something like this from happening. Or the other way around would be that you have someone doing a PhD as part of this project, and for some reason they are forced to leave the project team. Can they still continue working with the data for their PhD? So these are scenarios that should be considered when the project starts, so that everyone who needs access to the data as part of the project can have access to the data. Yeah. So collaborative projects are, in terms of IPR, can be quite a challenge.
So this is my wrap-up slide on intellectual property rights. In terms of reusing, keep in mind that, of course, you have to pay credit to the data creator of origin, so the copyright holder. In regard to the conditions of reuse, you should really be careful and check for the conditions of reuse before you reuse the work of someone else, because it might affect your research output. And the worst case scenario is that you have great results, but you're not allowed to publish these results according to the fact that the conditions of reuse simply forbid it. So check for it before, and if you're not sure about what the conditions of reuse mean, get in contact with the copyright holder of origin or the archive or whoever has defined the conditions of reuse and ask for permission, okay? That's the best thing you can do. The worst thing you can do is that you have to ask for forgiveness afterwards. In regards to data licensing, I think we mentioned most of the things here already. Of special importance is how sensitive the data are that will be licensed. And what I'd like to show you in this regard, but this is something you cannot really see. Can I make this bigger somehow? Yeah. This is the user license of cases. And what you can see here, we have 4 different access categories. In general, we provide data only for academic research and research related to academics. Category 0 are simply data which are free for everyone. So the resource of the last championship, world championship in soccer is something which is really not of interest, so everyone might use it. We have this category where the access is restricted to academic research only. And then we have 2 additional categories which define a high level of access, because for both categories, researchers are not allowed to simply use the output of their research, but they have to get permission to use the output of the research from the archive first. This is what is done in the CQ Data Center, and even harder, from the data creator of origin. So this is where the data creator of origin, the copyright holder, can really control what is done with her or his data afterwards. And to discuss in which category your data should fall once they are archived is something that will happen during the archive process. According to this category C, which is a general category in most of the social science data archives, you should keep in mind that maybe you do not want to be annoyed by all these requests for reusing your data and checking the outputs that has been produced with your data. So in general, it is enough to say that the archive might check it. There are people who know how to do this. In regard to intellectual property rights, so licensing your data, I forgot to mention the EU directive, which is of importance. I thought it would be one of the slides, but it wasn't. It is from 2001, and it's the EU directive 29. So it's 2001/29, which simply defines the basic requirements of intellectual property rights in research in the EU. And a second thing I've forgotten to mention in regard to archiving your own data or licensing your own data, you should care about the intellectual property rights of third parties. Especially in psychological science, we have this quite often, that researchers reuse questionnaires of other projects. They are allowed to reuse these questionnaires, but they are not allowed to archive these questions, because the copyright of these questions is up to someone else. And of course, archives are not so much interested in data where it is unclear what the data are about, where the question of origin cannot be archived and not be handed over to someone else. These data cannot be reused, and so archives are in general not so interested in archiving them.
I looked into this questionnaire, copyright, and I have the impression that actually questions as such are not copyrightable. But what's copyrighted is a brand, the name of the questionnaire. But the copyright does not extend to actual questions.
Are you sure?
Rather, because it was argued in the case of tax blankets, or like the forms. Someone makes some forms and it makes it really easy to fill in the taxes. And because it's used to gather information, not to give that information, it's not copyrightable as such. But we can copyright feedback forms that people read, or you can copyright the name of the questionnaire, but I have the impression that the questionnaires as such are not copyrightable.
So the advice I could give you is don't believe in your impressions. Ask if you're allowed to use these questions and to archive these questions or to share the questions with others. Simply ask for this permission.
Well, that's always nice. Yes.
And of course it might be that it's only the questionnaire of origin which is under copyright, and of course you should always citate where you got the question from. But in this context I would ask, simply to ensure that you did nothing wrong, because it is you who will be punished afterwards.
Yeah, and social pressure, and so it's always nice to ask.
Any questions? If not, we are perfectly in time, and we will have 15 minutes coffee break now.